You understand it's your credibility is something I have to look at, and so
Yes.
I want to go over this with you to make sure I'm understanding and that you understand.
Okay.
The state has filed a notice of impeachment and range of punishment. It is alleged, and they have records to show that you were arrested or convicted of theft of property in Dixon County on May the 15th of 1998. I think part of your confusion is in 1998, there were 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 convictions all taken care of at one time when you said they all rolled them all together.
Yes, sir.
Does that help your memory any?
Was it you? I was convicted in 1988?
Yeah, you would know better than me, but I'm looking at the records.
Okay, that may be right. That's a long time ago.
And that you had a conviction of theft of property in 98, that you had a conviction for theft of property again in 98, that you had a conviction for burglary in 98, that you had a conviction for theft of property of thousands to $10,000 in May of 1998, that you were convicted of auto burglary in 1998, and another count of auto burglary, that you had another conviction for burglary of other than a habitation in 98, and you were convicted of burglary other than a habitation, another count in 98, and you were convicted of theft of property in 98. And then it says those are the 10 that all got wrapped up together. But it also alleges you were convicted of theft of property in Dixon County in February of 2002. Does that ring a bell?
No, sir. Honestly,
They allege you were convicted of burglary in Dixon County in 1992. Does that ring a bell?
In 92?
92.
I was,
That you were convicted of shoplifting, a misdemeanor shoplifting in 2015, 11 years ago. Does that ring a bell?
that does. The 2000, you said 1992? I'm sorry.
It also says you were convicted of the offense of patronizing prostitution in Shelby County in March of 2010. You remember that?
That was dismissed.
It was. It says you were convicted, but you're saying it was dismissed.
Yes.
Uh,
I'm sorry, did you say 1992?
No, that one
On
was,
one of them?
there was a 1992 conviction of burglary, according to this document. You understand that the state
Yeah,
will have copies of all convictions.
Yeah, but I was 15 in 1992.
Okay.
When I wasn't.
All right. State, have any other questions? You want to ask him any questions based on what I asked? Step down. Mr. Baker, you may call your next witness. State, have any proof you wish to offer? Sergeant Anderson, if you'll come around, please. Yeah, would you hand me the? Raise your right hand and face the clerk, please.
Will you state your name for the record, please?
Sergeant Ronald Anderson,
And where are you employed?
the City of Dixon Police Department.
Did you have an occasion to recently to come in contact with Mr. John Wren?
Yes,
And was that while you were on duty?
yes.
Can you tell us about, well, let me ask you this. Did you or another officer seek charges on Mr. Wren after your encounter with him?
Yes.
And do you know what those charges were for?
Multiple charges, including felon in possession of a firearm ×2, possession of illegal narcotics for resale with different types of narcotics, and some drug paraphernalia charges as well.
All right. Can you tell us, was this the date of April the 14th of 2026?
Yes.
All right. And can you tell me about the encounter with Mr. Wren on that day?
Yes. Our agency was dispatched to the area of Smoothie King located in the shopping centers on Thornton Drive for a report of a suspicious male subject.
Your Honor, this is a bond hearing, and I think as to why he is reporting, it's not necessarily offered for the truth of the matter so much as a basis for why they were dispatched out and what they were looking for.
I'm overruling the objection. I'm allowing it in because it's being admitted to show why the officers took certain action rather than for the truth of the matter.
Go ahead.
I responded to the area for the reports for the call of service, and I encountered Mr. Wren sitting inside of a pickup truck matching the description of the vehicle that was called in on. As I approached the pickup truck to investigate, I noticed the driver's door was ajar. I saw Mr. Wren sitting in the driver's seat of the vehicle with a pipe in his hand and a lighter in his other hand. Through my experience, this pipe was indicative of smoking illegal narcotics. So in a clearly identifiable police uniform, when Mr. Wren noticed my presence, he tried to slam the door on me. So
Well, certainly, Judge, the fact that he,
This is a motion to ask me to set aside an order revoking the bond. The state is proceeding, I'm assuming, on the original revocation to show why it was justified.
yes,
And
Judge.
it's also a motion for me to consider setting you a bond, but the first step is whether or not the court was justified in revoking the bond, so overrule the objection.
You can go ahead.
after Mr. Wren noticed my appearance, my clearly identifiable police uniform, and tried to slam the door on me, I had to force the driver's door open and order Mr. Wren to step out of the vehicle. Mr. Wren, with the drug paraphernalia that he was possessing at the time, began to try and tamper with said evidence and stash it inside of the truck as he exited the vehicle. He then physically resisted to the point that I had to grab him by the wrist and try to place him in handcuffs.
Sustained as to his answer, you may restate your question.
What did Mr. Wren do with the drug paraphernalia?
Mr. Wren turned away and tried to place the drug paraphernalia in the seat amongst a pile of items in the truck so it could be hidden.
All right, and
Conclusion without a basis. Because of Mr. Wren's time, that requires
Your Honor, obviously he can testify to what he's observed.
Overrule the objection.
And then when you attempted to, I presume you at this point in time attempted to get him out of the vehicle, what did John Wren do?
Mr. Wren, as I grabbed his wrist to detain him and place him in handcuffs, pulled his hand away from me and became argumentative.
Okay. Were you able to get him into custody?
Yes,
Okay. Did you then search, due to the paraphernalia, did you search the truck?
yes.
All right. Did you find any other items besides the paraphernalia?
After Mr. Wren was taken into custody, when I went back to the vehicle to retrieve just the items that I noticed Mr. Wren in possession of, I then also observed other items of drug paraphernalia in plain view.
Such as, what did you observe?
The first item that I observed was a tray that had multiple clear baggies sitting on top of it filled with a white powdery residue.
Did you locate any drugs in the vehicle?
Yes,
Do you recall, obviously they are, I presume they have been sent to the lab.
yes,
And do you have experience in observing drugs and determining by characteristics as to whether or not they appear to be certain substances?
yes.
All right. And what did these substances appear to be?
As I stated earlier, there were multiple substances, but one of the substances in most quantity was what I believed to be crystal methamphetamine.
Do you know approximately, based on weighing, how much that substance weighed?
At this time, I do not recall.
Okay. Do you know if it was, well, I guess Your Honor, may I approach with
You
the
may.
affidavit?
Your objection is what?
It's the affidavit, Judge, that's on the court's webpage, but I'm happy to.
Pass it to Mr. Baker and let him review it. At this point, we're not dealing with a discovery issue at a trial, but rather a preliminary hearing.
I'll let you finish reading that, and then when you're done, I'll grab it and you can tell me the amounts if you don't mind. Value or amount of estimated of the methamphetamine.
Judge, I'm going to object to this testimony from this recollection.
Were you present with Officer Kane when he did the report and filed the affidavit? And were you present during all of this interaction with Mr. Wren?
Yes,
And did you physically see the items that were recovered?
yes,
Were you physically, or not physically, were you aware of what it looked like and the amount that it was weighed?
yes.
I note your objection, overrule the objection. I think the document is sufficiently shown to be a document that he could use to refresh his memory.
You can answer.
The suspected methamphetamine that we located weighed 144 grams.
Did you locate any other drugs that appeared to be, any other type of drug?
Yes, we located what we believe to be crack cocaine, fentanyl, as well as suspected MDMA, or ecstasy for the street name.
Okay. Did you locate any weapons?
Yes,
What did you locate?
we located a .45 caliber Kimber pistol, and we also located a Mossberg 12-gauge shotgun.
Was there anything special about the Kimber pistol?
The Kimber pistol its serial number was ran through the national database, as well as the shotgun. And the national database came back to show that the Kimber pistol had actually been reported as stolen.
Again, this is a bond hearing and it's reliable hearsay if it went through NCIC, Your Honor.
Overrule the objection.
All right. Can you tell us about the pistol again? I'm sorry.
Yes, the serial number on the Kimber pistol was ran through our dispatch, who ran it through the National Crime Database.
Objection now that you're saying it's hearsay.
This is a standard police procedure as far as checking that whether or not a vehicle or an item has been stolen. I find it to be reliable hearsay for purposes of a bond hearing, therefore I overrule the objection.
Was the pistol reported stolen?
Yes,
Okay. And is there anything unique? I'm not as familiar with the guns, but is there anything unique about a Kimber or Kimber pistol? Is that a nice gun?
all that I know is they are expensive.
They are expensive.
Now, Sergeant Anderson, Mr. Wren was charged with other crimes as well, and do you know where that case is, this April 14th case, in court? Is it in General Sessions Court, or do you know if it's been bound over?
As far as I know, it is still in general sessions.
Okay. Do you know whether or not any digital scales were located in the vehicle?
I don't recall.
All right. I don't have any further questions. If you'll answer any questions of the,
Mr. Baker, do you have questions?
Officer, did you weigh this 144 grams of suspected methamphetamine?
Officer Smith did.
Well, then how do you know it was 144?
It's what the scale he used read.
Were you there when, did you watch it?
Did I watch him weigh it?
Yes.
No.
So you have no firsthand knowledge of this weight, correct?
Correct.
You don't know if the scale was tared, correct?
Scale we've used to weigh everything else, sir, but I do not know.
Do you know how to tear the weight out of a scale?
No, sir.
You don't. So you don't even know how to weigh drugs.
I know to turn the scale on and place the item on the scale and use a readout.
So you don't tear them, you don't calibrate them, anything of that nature?
No.
Sustained. Officer, pull that microphone slightly toward you. The base will pull toward you. There you go.
Now, why was who dispatched, who was the caller that called in the vehicle that sent the police out there?
I don't recall.
You don't recall, or you wasn't told?
I just don't recall.
Don't recall? Is it in your report? Did you make a report?
It should be in the report that Officer Smith wrote.
Were you the arresting officer or Officer Smith?
Officer Smith.
No further questions.
Redirect. Thank you, sir. You may step down and have a seat. State may call your next witness. Let's have you spit your gum out too.
Oh, sorry.
will you state your name for the record, please?
Officer Jacob Brake.
And where are you employed?
I work for the City of Dixon Police Department.
Officer Brake, were you involved with an interaction with Mr. Wren on April the 27th of 2026?
Yes, ma'am, I was.
And can you tell us about the interaction?
I was a backup officer to Corporal Hollis's traffic stop with Mr. Wren and a female. When we got there, whenever I arrived as backup, there had been an altercation with Mr. Wren reaching into his pants trying to grab something. Whenever I got out of my patrol car, there was a white bag. There was a small bag with a white rock inside of it. He was ultimately detained and put in the back of a car when Agent Pirtle with the Drug Task Force deployed his canine, which gave a positive alert to the odor of narcotics inside the vehicle. Upon a search of the vehicle, we located some paraphernalia inside, along with some other substances that were located on Mr. Wren.
All right, when you say paraphernalia, what was the paraphernalia? Do you recall?
Some crack pipes that were inside the vehicle.
Okay. And you were kind of soft-spoken when you were talking about the drugs or suspected drugs that were located. Do you recall what those suspected drugs might be, based on your experience as a law enforcement officer?
There was
Or what it
approximately-
looked like, I guess.
There was a brown substance that appeared to be heroin, and then there was a pink powdery substance, which what we won't know what it is until it comes back from the TBI, but we're assuming that it's fentanyl.
All right. And was there cocaine found as well, or crack? I think you said one rock.
Yeah,
Is that
I
right?
believe it was cracked. It was in a small baggie.
Okay. And was there anything else of note in the vehicle on that day?
Not that I can recall. There was a lot of stuff inside the vehicle. There was a lot of suitcases, clothes. There was a lot of stuff inside the vehicle.
So there were suitcases inside of the vehicle?
Yes, ma'am.
And you said another person was also with Mr. Wren?
Yes, ma'am. A female.
Now, the following day, April the 28th, did you get a search warrant to search the vehicle that Mr. Wren had been in the day before?
I did.
All right. And during that search, let me ask you this. You were granted the search warrant, is that correct?
Correct.
Okay. And during the search, did you locate anything additional in the vehicle?
Yes, we located some more what appears to be crystal meth, a digital scale, and some more of the pink powdery substance, I believe.
And do you know approximate quantities of the methamphetamine and fentanyl?
I would have to look back at my report. I don't remember an exact weight of that.
Or may I approach with the affidavit?
You may.
I will ask you that.
Okay.
What appeared to be methamphetamine and what appeared to be fentanyl?
Yes, the methamphetamine was in 2 bags, and it was approximately 10.5 grams. And the other bag was around 6 grams.
All right. And did you review information, statements by Mr. Wren in regards to getting this search warrant?
Yes, I've reviewed jail calls.
And what did Mr. Wren say in the jail calls that led you to get a search warrant?
I don't remember in quotes exactly what it was, but he was telling somebody.
This witness can testify as to his memory of what he observed in this court's opinion. Therefore, it's not a basis for him to be disqualified from testifying about it, but it is something that he can be cross-examined about whether or not his memory of that event is reliable. That's true.
If somebody comes in, if this audio exists, of what was said by because now we're substituting stood or interpreted as now the words of somebody else.
I'll allow you to respond if you want to on the record.
Judge, the response would be, these are statements made by Mr. Wren that led the officer to getting a search warrant, and I think it's relevant to explain basically the basis for it.
Overrule the objection. This is not a situation where the video is being played and an officer is along the way interpreting it for the jurors or the court to listen to. This is instead being allowed by this court to allow the officer to testify about essentially how they were able to go about getting a search warrant. And for that reason, his memory of what was said in that and how it led him to a search warrant. The search warrant itself would set forth those facts that you're objecting to. And if it gets to a point where that becomes more relevant and more essential, then that would be a question for the court to decide. Here is just a statement of what happened and why they took certain steps. And for that reason, I overrule your objection.
Did Mr. Wren make any statements on jail phone calls in regards to further contraband being located in the vehicle?
Yes, ma'am, he did.
Okay. Did you locate the contraband where Mr. Wren said it would be in the jail phone calls?
Yes, ma'am, we did.
I do not have any further questions. Judge, I would like to introduce certified copies of each of these charges that are pending.
All right. Make those as, I guess it's Exhibit 1 to this hearing. Mr. Baker, you may cross-examine.
Detained when you got on scene?
I'm sorry, sir, I couldn't hear you.
Was Mr. Wren already detained when you got on scene?
Yes, sir, he was.
Okay, was he already cuffed up into the car?
He wasn't in the car, no.
Okay, but he was cuffed up?
Yes.
Okay, and who was the initial officer that detained or stopped?
It was Corporal Hollis.
Corporal Hollis. Was it initially a stop for somebody being in a turn lane?
I believe so. He was driving in a turn lane.
Yeah.
I'd have to review his citation for that matter.
Right. Do you have any indication what would correlate a stop for being in a turn lane to a search?
The positive alert to the canine for the vehicle is why we searched.
When did the K-9 arrive? At what time? How long transpired?
I don't know. I'd have to look at that CAD card if it's on there. I couldn't tell you.
It could have been more than 15, 20 minutes,
I don't believe it would have been that long, but
but it could have been.
I can attest to that.
Okay. And now you said that there was some, you kind of danced around. There was a phone call saying there was something that would indicate that there was contraband in the vehicle.
Correct.
Was there a statement on that phone by another party that indicated that?
That there was narcotics inside the vehicle from,
Right.
I'm trying to figure out, so are
Yeah,
you
who made
saying
the
your
statement?
client didn't say that the narcotics were in the vehicle?
I'm not saying, I'm asking. Who said that on the phone? Was it Mr. Wren or the other party that was calling into the jail?
Mr. Rim was making outgoing calls.
All right, well, which party made the spoken statement that indicated there was contraband there? The other party that he had called or Mr. Wren?
Your client did.
All right, but you don't recall what he says. Is that a fair statement?
Directly, like in quotes, every single word, I do not.
All right, and you would agree that that vehicle that you stopped didn't belong to Mr. Wren, correct?
I don't believe it did.
It didn't. And at what time frame did those narcotics get in that vehicle? Before or after Mr. Wren obtained possession of that vehicle?
I can't attest to that. It was, once him and the other female were taken to jail, it was taken to a secured tow lot.
All right, okay, now, so there's a female there on the scene at the time also? How much of these drugs were hers?
Hey,
Couldn't tell. I'm not getting a lot of answers where, a minute ago, the DA was picturing this, that Mr. Wren is on, it kind of insinuates that this is his car and he's got dominion over it. And all these drugs are his. But now I've got a third party and no ownership of the car. Would you agree that that begins to be suspect of who those drugs belong to?
I have an answer for you.
Well, when the drug task force come out, are they tasked with investigating this type of crime?
Sometimes they are.
So they don't investigate these crimes?
They do investigate narcotics crimes, but I can't attest to what they do.
So they don't care who actually owns these drugs, just whose vehicle we find it in?
Can't attest to what they do.
Outside the scope and argumentative. Sustain the objection.
Okay. No further questions, Judge?
Anything further for this officer? Thank you. You may step down. You have any other witnesses? Any rebuttal proof that you wish to offer, Mr. Baker? You wish to be heard in argument?
Legislature's already laid out the remedy for this, and that remedy's been met. If you heard Mr. Wren testify, his bound was doubled on the new charges. That's exactly what 148 says. If you're out on bail, charged with the commission of crime while free on bail, remedy isn't, oh, I'm snatching your bail. The remedy is to double the bail, and that's exactly what happened here. And instead of the DA's office following the procedure that the legislature laid out for this, we want to revoke bail on top of that. I disagree that the bail should have been revoked at a minimum. There could have been some additional provisions as the statute allows. You could have put an ankle monitor on him for drug use or scram or whatever we needed to do. For example, we have a whole section for DUIs. If you get a DUI while out on a DUI, they don't say, okay, your bail's gone. Double the bail and add these conditions is the first line of remedy. So now what the state wants to do is you've caught a new charge. One of the charges, we don't even know who called it in or what's, it's a traffic stop. The testimony is from an officer that I don't know who owned, it's not Mr. Wren's car. I don't know whose the drugs is. There's now another party in the car. And okay, now I want him to go to jail because I automatically say, this is the conclusion. Because I am the police, found this car that doesn't belong to the driver. I don't know who owns the drugs. There's another party in there, but because it's Mr. Wren, he's guilty. It's all his. That's the proof. That is absolutely the proof you just got here, Judge, which is the reason why we don't allow the government to say, okay, I'm going to get you a bail. We're all guaranteed bail in this country to protect from strong-handed tactics of the government. Because the fear is exactly as the legislature put here, is that the government wanted to lock you up. They know that, oh, he's going to get granted a bail, but if I go get another petty charge on somebody, whether it's legit or not, I'll just revoke his bail. I've got him. He's in jail. And that's exactly what the state wants to do here. The remedy is to set another bail and let Mr. Wren flesh out, one, the constitutionality of these stops, who owns the drugs, and so forth. When you get back to the Smoothie King, we don't have any 608 knowledge. I don't know any firsthand knowledge here about the stop, all of that stuff. We don't even know the caller. And I think the court can take judicial opinion, judicial notice of, I think it's Florida versus JL, where the case where the Supreme Court ruled on an anonymous caller with a black man with a gun. Police shows up in the parking lot of an apartment complex, comes into that complex, grabs the first black man I see and starts searching him. Supreme Court says, oh no, it don't work that way. You got to have some type of independent corroborating evidence before you just start violating constitutional rights. As far as I know, that's what happened at Smoothie King. So the government wants you just to assume there are facts in the evidence, such as, okay, I got a felony conviction at 15, which I find implausible, but they're presenting these evidence unchallenged because they know, okay, well, unchallenged, but I can still get the citizen's bail revoked and incarcerated because it's John Wren, because we've already established that we're just saying it's his because it's John Wren. Looking at the objective facts in the case from what we know or heard of, you can't conclude that. I'd ask for the bail to be reinstated, Judge.
Judge, the state filed a motion to revoke Mr. Wren's bond on April the 16th, giving notice to his attorney, Olin Baker. On April the 27th, in front of Judge Turnbow, his bond was revoked due to the new offenses that took place on April the 14th. note, Judge, that Mr. Wren was not present on April 27th when his bond was revoked. However, on the afternoon of April 27th, he was arrested by Officer Jake Brake with new drugs and a suitcase in his car, or suitcases in his car. The next day, or on that date, he makes statements that indicate that there are additional drugs in the car in which a search warrant is executed and additional drugs are located in the car. You heard evidence, Judge, of the original offense on April 14th that was the basis of my original motion to revoke. However, Judge, he has then committed new crimes since that time and that you've heard evidence on today. So, Judge, here he is charged with, before the court originally on the 2025 CR 120, with possession with intent to sell or deliver cocaine, possession of a handgun by a convicted felon, possession with intent to sell or deliver fentanyl, drug paraphernalia, all of which was occurred on May 9th of 2025, and he is set for trial in that case, Judge. So here we are out on bond. Mr. Wren is charged not once, not twice, but 3 separate times with 3 separate different offenses involving drugs, guns, and also a stolen gun. Mr. Wren agreed with the questions that Your Honor asked, that he did in fact have multiple felony convictions, and the state has filed notice of enhancement of 13 prior felony convictions. Mr. Wren does not need to be out on bond. For the safety of the public, in new crimes being committed, I would ask that his bond remain revoked. Thank you.
This court respectfully disagrees with Mr. Baker's argument that this case is controlled by 4011-148 because that statute is a person that says, the title of it is bail for a defendant charged with commission of a crime while free on bail. But when you read the language of that statute, subsection A says if a defendant has been released pursuant to 4011-118 or 4011-116, then that statute applies about doubling the normal amount of the bond. What is 4011-115? 4011-115 is releasing someone on an unsecured bond or own recognizance. So when the statute applies, it applies to double the normal bond if someone commits a crime when they've been released on an own recognizance bond or with an own OR bond that contains certain conditions. So this court does not find that 4011-148, as Mr. Baker says, is the controlling statute. Instead, we are controlled by 4011-1. I've got to get back to it. 4011, which has to do with the revocation of a bond while a person commits a new offense while on bond. And that statute, again, as I've cited several times today, is 4011-141. 4011-141 states the following. If after the defendant is released upon personal recognizance, an unsecured personal appearance bond, or any other bond approved by the court, the defendant violates a condition of release, is charged with an offense committed during the defendant's release, or engages in conduct which results in the obstruction of orderly and expeditious progress of the trial or other proceedings, then the court may revoke and terminate the defendant's bond and order the defendant to be held without bail pending trial without release during the trial. And this court went over the prior record of the defendant because his credibility on this issue is a matter for the court to consider as well. And this court is of the opinion that Mr. Wren was either incapable of remembering all of his prior convictions or was less than forthcoming and credible with the court as a witness. This court is considering the matter to reinstate the bond based on the fact that it's essentially asking me to revisit the court's ruling by Judge Turnbull on revoking the bond. And This court is of the opinion that Judge Turnbow made the correct decision at that time, and this court affirms that decision and continues to order that the bond of the defendant in this case be revoked and that he be held pending the trial based upon the commission of new offenses or being charged with new offenses, and further based upon the testimonial evidence that was introduced from the two officers that testified here about what they themselves saw and observed of Mr. Wren's. Mr. Baker may argue at trial that the ownership of the drugs and so forth was not something that could be proven, but for purposes of the bail hearing, the court does find that there's credible evidence that Mr. Wren was engaging in criminal conduct and that he was engaged in possession of drugs and possession of a firearm, more than one firearm, when that was illegal for him. Based upon those facts, the court finds that the bond revocation should remain in place. That's the judgment of the court. Mr. Wren will be held in custody until his trial. So. Mr. Wren's case set for trial? Do you want to set it for status or trial?
I believe his new cases should go to grand jury this time, unless they didn't meet the cutoff, because I think they were just maybe bound over last week. So he'll either go to grand jury in June or at the latest in July. So I would just ask maybe for a September status date, so they can all join together.
I got me in a pickle. I haven't been retained, obviously, since he's in jail on these new charges, so I can't.
Well, I thought you were his lawyer. You've acted like his lawyer.
Only for the bail issue.
I mean, you, is you is or is you ain't, as they say.
Exactly.
Well, let's go ahead and set it for status on the June 23rd, I'm sorry, September 23rd date. And that'll give you time to determine whether or not you is or ain't. So. Mr. Atchison, you have something?
Can I approach?
Yeah. I thought that was one of those things where you were just saying it while you walked up there. Who do we have left? Rodrigo Flores.
Judge, this is Mr. Rodrigo Flores. He is charged in 25 CR 256. We've reached an agreement with the state in which Mr. Flores would like to enter a no low contendere plea. He would enter a plea to count one, which is DUI second offense. Receive a sentence of 1129 to serve at 75%. That's day for day on the 75. Count 2 through 6 would be nollied in settlement. Count 7, he would enter a plea on vandalism, 60 to 250,000, be felony. That's 8 years suspended to probation, consecutive to 1, 8, and 9, and I'll explain that here in a second. Count 8, he'd enter a plea on one count of felony retaliation for past actions. That's an E felony. Receive a year to serve at range 1, 30% concurrent to the count 1. In count 9, attempted assault on a first responder. It's an A misdemeanor. Receive a sentence of 1 year to serve at 30%. That's also concurrent to count 1. And as a condition, we're going to need a restitution hearing set to determine the exact amount of damage. I think right now we're pretty much aware of 56,000 in damage, but it's higher than that. Loss of license for 2 years. Mr. Flores will pay a $600 fine and court costs, and if he wants to continue to maintain his restricted license, he'll need an interlock. And he's going to report to jail on 6/26/26 at 6 p.m. And the requirement is probation reporting will be in person. I think that's, and I have the jail credits, I believe that is 10 days, Judge. I don't remember the exact dates, but he has 10 days of pretrial jail credits.
Because he's going to serve 11/29 at 75% release eligibility day for day.
That is correct, Judge.
All right, Mr. Flores, raise your right hand. Let's place you under oath. Step up to the microphone and state your full name.
I'm Rodrigo Flores.
Mr. Flores, you are here today charged with a multi-count indictment. You've heard your lawyer go over what the agreement is, but have you seen or been shown a copy of the charges? Talked them over with Mr. Baker and discuss with him the range of punishment you're facing as well as any possible defenses you might have.
Yes.
Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that a plea of no contest means that you are not going to admit you did anything wrong, but you're not going to deny or contest the state's evidence, and they will tell me what their evidence would be at trial, and I'll use that evidence to find you guilty. You understand that?
Yes, sir.
Do you understand, however, that you have a right to a speedy and public trial by jury, and you would have the right to have a lawyer to represent you and could have one appointed if you cannot afford one?
Yes, sir.
You understand at trial you'd be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
Do you understand that if you went to trial, you and Mr. Baker could confront and cross-examine all witnesses the state called to testify, and you could bring in your own witnesses by use of a subpoena?
Yes, sir.
Do you understand that you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that judgment and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve the agreement your lawyer has worked out.
Yes, sir.
You understand that's going to result in a number of convictions, including driving under the influence, that will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, sir.
I've been handed a document called a Notice of DUI Punishment that purports to bear your signature. Is that your signature on that document?
Yes, sir.
Did you and Mr. Baker go over it? Do you feel like you fully understand all of the enhancement provisions of the law set forth on this document?
Yes, sir.
All right, is your decision today to plead no contest, is that voluntary on your part?
Yes.
Anybody forcing you to do this against your will?
No.
You understand I can't accept your plea unless I'm satisfied there are facts to support a finding of guilt.
Yes.
Then I want you to listen as the state tells me what their evidence would be if this case went to trial.
Oh, yeah, come on.
Your Honor, if the state would go to trial, it would show that on or about October the 18th, 2025, officers with Dixon Police received notice of a security alarm going off at 220 Tensco Drive in Dixon, operating as Sewing Parts Online. Officers arrived and found the defendant, Rodrigo Flores, on scene with his vehicle. Officers learned through the investigation that Mr. Flores drove his vehicle into the building multiple times in different areas, causing serious damage at an amount greater than $60,000. Mr. Flores showed signs of impairment and told officers, quote, "just get me," end quote, indicating he had done something wrong. Mr. Flores gave inconsistent statements as to whether he was in a wreck or not before finally admitting to being in such. Mr. Flores suddenly became aggressive with Officer Salas, at one point threatening to hit him. Officers took Mr. Flores into custody where he fought Officer Slack, which is the basis of attempted assault on a first responder. Later on, Mr. Flores threatened to kill the officers for their past actions of arresting him. Mr. Flores did urinate on himself during this time as well. Mr. Flores refused to provide a sample of his blood for chemical testing where a warrant for his blood was secured. Mr. Flores did have a BAC of .276, about 3.5 times the legal limit. These actions did occur in Dixon County, Your Honor. And this is, for the record, a DUI second, but since he's serving that's the basis of the 2 years of taking his license as well as the $600 fine and cost, it is his second.
All right. Mr. Flores, you understand that's what the state would try to prove if this case went to trial.
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel like Mr. Baker's done a good job of representing you competently?
Yes.
Mr. Baker, do you know of any reason you should not enter this case?
I do not, Judge.
Anything further from the state?
Your Honor, just to note, we are providing Mr. Flores a grace period of 30 days to get his affairs in order. And if he does not report for this 9 months to serve, it could be a basis the state believes of violating his probation for a full sentence of 9 years, and it could be a felony failure to appear as well. So just for the record, if he does not report, that could happen.
All right. Then Rodrigo Flores in docket number 2025 CR 256, upon your plea of no contest to count one, I find you guilty, sentence you to 11 months and 29 days in a county jail to serve at 75% release eligibility for day for day, which equates to a 9-month sentence of day for day. Your license to drive is suspended for a period of 2 years. You're ordered to pay a $600 fine and cost. You must obtain an interlock for your vehicle before you can get restricted license. The vandalism charge on count 7, you're found guilty, sentenced to 8 years in the Tennessee Department of Corrections, suspended to probation. That will be consecutive to counts 1 and 8 and 9. Count 8, you're found guilty of retaliation for past actions, sentenced to 1 year to serve as a range 1 offender concurrent to count 1. Count 9, you're found guilty of attempted assault, sentenced to 11 months and 29 days in the county jail to serve at 75% release eligibility day for day. That will be concurrent to count 1, and a restitution hearing will be set if necessary. He must report to the jail on or before June 26, 2026, 6 p.m. And as was indicated, your failure to report on that date, you're now on probation. You commit a new crime, you violate the law in driving, you do anything that's violating the law, then you will go to prison for 9 years rather than serve 1 year. You understand that?
Sure.
You must report to probation in person. He'll need to see the probation department. So, all right. We have anybody else back there? Who was to serve his time? Pardon? Whose lawyer, who is his lawyer? Public defender?
He's aware, Your Honor.
What is it? Well, I mean, we played him on a DUI 4th.
I think he'd rather just flatten his sentence and serve the whole year, put it into effect for a year to serve as the E felony rather than doing probation. That's what Mr. Talbot indicated to me, and
Bring out Mr. Dorman and round up Mr. Talbot. So we now have 5 or 6 things set tomorrow. And we're doing, does that include the Houston County Zoom? Oh, well, don't say anything else, because I do have to leave at noon. So.
Your Honor, this is Mr. Dorman again. He advised me that he would like to amend his plea agreement. There's no opposition from the state on this. He requests that he be allowed to amend his plea to where, rather than going on probation, he will instead have his sentence of 1 year to serve with the Tennessee Department of Corrections. He has decided that that is better for him.
All right, Mr. Dorman, raise your right hand. Let's place you under oath. Mr. Talbot, I'm going to allow you to put on the record what it is he's requesting.
Yes, Your Honor. So Mr. Dorman was previously, he had settled his case by entering an agreement for him to have a 1 year TDOC suspended to probation. but for 150 days to serve in jail. And that was going to be a 30% release eligibility sentence, so standard release eligibility, range 1. The only change he wishes to make is that the probation part be eliminated. He does not want to undertake probation. I've discussed this with him. He thinks it would be better to simply have the sentence in effect with all the standard terms, 30% release eligibility. Of course, he must serve the 150 days first, which is mandatory under the statute, before any consideration of his parole on that sentence. I've explained all of that to Mr. Dorman, and he thinks that that's what's best for him.
All right, Mr. Dorman, you understand that I can amend your plea to amend the sentence that I imposed to, instead of requiring you to serve 150 days in jail and then go on probation, that I can order that you serve a simple 1 year in jail. Do you understand that?
Yes, sir.
And that's what you're asking me to do, is that correct?
Yes, sir.
All right, then I will amend the judgment in this case to provide that he will serve 1 year, and that will.
The only thing I would make sure to say on the record is that the minimum time is 150 days. Even if he's 2 for wanting it, do credits.
He's got to do at least 150 days, but he can do the entire year or whatever the Department of Corrections deems to be appropriate for that sentence. So,
My experience, when it's a 1 or 2 year sentence, those are permanent release sentences. So once he gets back to it, of course, he can try to work 2 for 1, whatever else with them, that's fine.
all
Once
right,
he does at least 150, that's fine.
then that will be the judgment of the court. Thank you.
Thank you, Your Honor.
Thank you.
So we are concluded until tomorrow morning at 9 o'clock.
Yes, sir. On, if I may, Your Honor, on the Nicholas Creech matter, I spoke with Mr. Creech. He does not want to proceed on that motion tomorrow, so we don't need to
All right.
do that, if that's okay with the court. I'm going to file a motion for a bond reduction on his behalf in his 2 cases that my office is representing him on.
Thank you for letting me know. So we're back down to 5 things.
I'm going out.
All right, now can you hear me?
Yes, I can.
All right. Are you Nicholas Harden Creech?
Yes, ma'am.
Mr. Creech, you are here today. We need to arraign you on an indictment here in Dixon County that has charged you with aggravated assault on a law enforcement officer, evading arrest with a vehicle involved, reckless endangerment, assault with bodily injury, evading arrest, resisting arrest, driving with your license suspended or revoked, and criminal impersonation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, I do.
All right, I'm going to appoint the public defender who's here in the courtroom with us. Mr. Talbot, Mr. Creech is here today and has filed a number of pro se motion, or a pro se motion for a bond and a source hearing modification filed by him on a pro se basis. Let's first of all go ahead and do the arraignment.
Yes, sir. I acknowledge receiving a copy of the indictment in this case and waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered on behalf of Mr. Creech, and we want to set a status date.
He's,
By the 16th, he's involved with, so I would suggest we add him to that date.
All right.
that's
Well,
fine, Your
I
Honor.
think the arraignment date is the
That would be the last day for a plea.
That's the plea date, Your Honor. Yes,
All
sir.
right. Plea day will be July 13th, the trial date is July 16th, and we'll set these cases on that same day.
I think that's what we,
So
right.
I presume she'll take pleas on that date.
As far as these motions go, I'd like to speak with Mr. Creech before he proceeds on anything.
All right. Mr. Creech, I think it's advisable for you to talk with your lawyer about this situation, especially since there's already a case set for trial in July. So we're just going to pass your motions without prejudice to let the public defender talk with you about your situation, okay?
Okay. When, okay.
I'll be in contact with you, Mr. Creech.
Mr. Talbot will be in touch with you as soon as possible to see what he can work out.
So what about the bond hearing?
That's what I'm talking about. You have a pro se motion for a bond, and if Mr. Talbot is recommending that you let him talk with you before we have that hearing, normally we would not have that hearing until after you had been arraigned anyway.
I'm going to come talk to you about your bond motion
Okay, when, do you know when that'll be?
as soon as I can.
Can't give you a definite date because he's got to be in court with me today and tomorrow, but he'll be there as quickly as he can, and then he'll start something in the motion to try to get you.
Your Honor, I filed this bond reduction, this hearing for this bond on this. One of them's for the circuit court for failure to appear, and the other one's for this indictment that would come up from general sessions. And I filed this bond reduction, this motion before the source hearing over a month ago. I was skipped over 2 weeks ago because they forgot to transport or forgot to come to Zoom court. And then I've got a real bad family situation. I got a bond. I need to get this bond reduced so I can bond out and get my affairs in order. And so I've been sitting here for 3 months now, awaiting this right here, to try to get something done on this. So, I mean,
I'm going to let you talk with him, but I'm going to, if you want to,
I'm trying to get this bond reduction done today.
if you want to talk with him,
Perhaps I can, oh, sorry, Your
then
Honor.
we can, I'll give him a bond hearing.
Yes, Your Honor. Perhaps I can join his Zoom link with Houston County there.
I'm going to exit him out of this one and let you just, there in Houston County, I'm going to take him out of this hearing and let Mr. Talbot come and talk with him by telephone or by Zoom, and then we'll come back to you. All right.
Yes, Your Honor. Thank you.
All right, who else do we have? All right. So I had accepted the plea, and this is for sentencing portion of the case.
Yes.
All right, then we'll resume this hearing. This is State versus Tomas Zurich in 2026 CR 131. All right, then resuming the situation, we had gone through all of the rights, and I believe the last thing I'd ask you is if you understood everything I explained to you during the explanation of your rights, and if you were satisfied with your attorney's services.
Yes, I am.
Mr. Flanagan, do you know of any reason he should not enter this plea?
No, Your Honor.
Anything further from the state before I pronounce sentence?
No, Your Honor, we did the factual basis with him asking the questions last time. Misdemeanors only, so I believe the factual basis has been covered.
All right, then Mr. Tomas Zurich, upon your plea of guilty to count 1, driving under the influence, find you guilty, sentence you to 11 months and 29 days in the county jail. That will be suspended all but 2 days to supervised probation. The loss of license will be for 1 year, $350 fine and cost. You'll have to attend either the victim impact panel or the DUI school. You will have a requirement of an interlock device. He may use the DUI Education Center for his initial 48 hours if he chooses. This will be served consecutively to 2023 CR 273. And we need a date when he's going to report, or do we have to set a date for him to report to that DUI center?
Your Honor, what we typically do, it takes about 6 weeks to get an actual weekend, and I realize it takes time. So my rule is, in the first 30 days since pleading, get on the schedule in the next 30 days. Then he'll work with probation just to ensure he does it 4 days. As long as he's scheduled in the next 30 days, I think that's.
No.
There's 2 cases, by the way. There's 2 cases he's pleading to.
All right. In 273, then he is found guilty, sentenced to 11 months and 29 days, except for 48 hours, suspended to supervised probation, loss of license for a year, $350 fine and cost, victim impact panel or DUI school. Interlock required, may use the DUI Education Center for the initial 48 hours, and that'll be up to him to schedule that within the next 30 days. All right.
Madam Clerk, I think the restricted license orders are also.
I have it here before me. All right, thank you. He needs to see the probation department before he leaves. All right, any inmates that we have that need to bring them up, please? Mr. Nixon? Joey Adarez Nixon? This is on a violation of probation. Mr. Nixon, was he placed under oath? Mr. Nixon, you have filled out an affidavit of indigency. I'll take a look at what you have. You may want to come around this side to avoid having to reach over Brandon. You make $3,250. What is that, weekly, monthly, or what?
Monthly.
What is it that you do?
Production operator, work in a factory.
Well, that's over $36,000 a year income, and therefore I do not find that you're indigent, and therefore I decline to appoint you an attorney. And you may, if you come in and produce verification that you've sought counsel with attorneys and have been unable to hire one, then the next judge may reconsider that. But at this point, with that type of an income, you do not qualify as indigent. All right. He's previously been set for June. When you come back in June, you need to be prepared to show the judge that you've attempted to hire a lawyer.
Okay,
All right, thank you.
thank you.
Judge, up next is Tierra Becky.
Your Honor, this is Ms. Tierra Bethke, and she is going to, subject to the court's approval, resolve her violation of probation case today with the following agreement. She will admit the violation and waive her hearing. Her probation will be revoked, and her sentences are going to be put into effect. She has significant jail credits that are noted on this plea sheet, and I'm going to have Ms. Bethke sign where it says defendant. Okay, there you go. Can you get a copy? Well, we're going to hand it in now, and so what I'll have to do is ask the court to send us a copy after it's entered. Then I can-
All right, Ms. Bethke, raise your right hand and let's place you under oath.
Yes.
State your full name.
Tierra Lane Bethke.
You can put your hand down now, thank you. You are here today on a probation violation. I want to make sure you understand your rights. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
You understand you would have the right to have a lawyer and to have one appointed as we've done with the public defender?
Yes, sir.
You understand that you would have a right, that if we had that hearing and I found you guilty, then you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading guilty, you're waiving your right to that hearing and to that appeal? All I'm going to do is order that your sentence be put into effect and give you credit for all your time.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to go ahead and enter a plea of guilty according to this agreement?
Yes, sir.
You want to go ahead and plead guilty and put your sentence into effect?
Yes, sir.
Okay. Then I find you guilty, order that you be revoked to serve your sentence with credit for all your time. And your lawyers put on there all of the dates that you're entitled to, okay? All right, thank you.
Judge, up next is going to be Connie Presley.
Judge, we're in the process of getting some medical records for Ms. Presley, so I'm going to ask the court for a new date on her, and I need to see her in the back to get her to sign some releases for me.
June 29th. June 29th. All right, reset for June 29th.
Thank you, Judge. If I may come on back in the hallway there. Thank you. That's all I have, Your Honor, if I may be excused.
You may.
Judge, up next is going to be Ray Dorman. You're good, you're good. Your Honor, this is Mr. Ray Dorman. Subject to the court's approval, he will settle his case, which is here before this court by information today. A negotiated settlement was arrived upon in General Sessions Court, and so we're here today. Pursuant to the information charging a DUI fourth, Mr. Dorman will plead no contest to the offense of DUI fourth, a Class E felony. His punishment will be 1 year TDOC at range 1, suspended to state probation. But for the 150 days jail that he must serve, he'll have credit for time he's already served. There will be a $3,000 fine, license revocation for 8 years. He has in-person reporting as a condition of his probation, and if he has any other cases, any other sentences, this would be concurrent with that. And then he has jail credits reflected on this plea sheet, and he's going to sign where defendant is indicated. I can move it down. I can move it right there. We'll use that right at the edge right there. And then, Your Honor, as well, there is a notice of DUI punishment, which I have gone over with Mr. Dorman, and he's going to sign and date that as well. I'm going to move this after this, so you can, there we go. That's probably better. Today's May 27, 2026. Yes, sir. All right. Okay, and I'm signing as your lawyer. And I believe that there is also a information which the defendant will need to sign as well.
I think I have it right here.
Yes, sir. One more thing. So this is the information we talked about. This is where you'll sign as a defendant right there. I'm going to try to find the very chair of this podium. Good to go. I've already signed it. Prosecutor signed it. This waives the indictment. process, so we can settle your case quickly. The court's going to
All
ask
right,
you some questions.
Mr. Dorman, raise your right hand. Let's place you under oath. Thank you. Step up to the microphone there. State your full legal name for the record.
Ray Osro Dorman.
Mr. Dorman, you're here today proceeding on what we call a criminal information. I want to make sure you understand what that is. I know your lawyer has done a good job of explaining it. Every person who is charged with a crime that carries the possibility of incarceration has an absolute right to have the evidence against them reviewed by an independent body called the grand jury of that county to determine whether or not they find probable cause to believe that a crime has been committed. You have the right to expedite the disposition of your case by waiving that, by entering a criminal information and waiving the grand jury step. And that's what's happening today. Do you understand that's what you're doing?
Yes, sir.
Do you understand that we'll proceed here as though it'll be the same as if you had gone through the grand jury? We're just skipping that one step. You understand that?
Yes, sir.
Do you understand what you're charged with, that you're charged with driving under the influence on a fourth offense, which is a Class E felony?
Yes, sir.
You understand what the evidence is against you, and have you and Mr. Talbot had a chance to talk about it, discuss the range of punishment you're facing, as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter this plea of nolo contendere. That simply means you're not going to admit you did anything, but you're not going to contest the state's evidence, and they'll tell me what their evidence would be if this case went to trial, and that's the evidence I will use to find you guilty according to this agreement. You understand that?
Yes, sir.
Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury in this court?
Yes, sir.
Do you understand that trial you would have the right to have a lawyer and to have one appointed, as I've done with a public defender?
Yes, sir.
Do you understand that at trial you'd be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that at trial, you and Mr. Talbot would have the right to confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by the use of a subpoena?
Yes, sir.
You understand that you would be presumed to be innocent, you would not have to testify or prove anything at trial, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading no contest, you're waiving your right to the trial and to the appeal? All I'm going to do is approve what your lawyer has worked out. But you understand and have that this is going to be on your record to make more severe the punishment you will receive if you're ever again convicted of a crime.
Yes, sir.
I've been handed a document called a Notice of DUI and Punishment that your lawyer has indicated you and he have gone over. Is that your signature on that document?
Yes, sir.
Do you believe you fully understand how every case, every conviction carries a greater punishment the next go-round?
Yes, sir.
Any questions about that form?
No, sir.
All right. Do you understand, or rather, is your decision to enter this plea voluntary?
Yes, sir.
Anybody forcing you to do this against your will? Do you understand I can't accept your plea unless I'm satisfied that you are guilty and that the facts support it? Do you understand that?
Yes, sir.
I need you to answer out loud on the record rather than just nod your head. All right, then I want you to listen as the state tells me what their evidence would be if this case went to trial, please.
Yes, sir.
Statement show that on or about May the 11th of this year, Officer Lefevre with Dixon Police initiated a traffic stop on a vehicle operated by Mr. Warman, speeding in the city of Dixon. Officer Lefevre noted signs of impairment for Mr. Warman, including the smell of Ms. Holmes that if he had not had anything different. Used by sample of blood testing. However, that sample was tested. Humphreys and Carroll.
All right, Mr. Dorman, I'm not asking you to agree with those facts, but you understand that's what the state's evidence would be if you went to trial?
Yes,
You
sir.
still wish to plead no contest?
Yes,
Are
sir.
you satisfied with your attorney's services?
I am.
You feel like Mr. Talbot's done a good job of representing you competently?
Yes, sir, I do.
Mr. Talbot, you don't have any reason you should not enter this plea? Anything further from the state? Then Ray Osro Dorman and docket number 2026 CR 148, upon your plea of nolo contendere to DUI fourth offense, I find you guilty, sentence you to 1 year in the Tennessee Department of Corrections. That will be suspended to state probation after service of 150 days in jail. With credit for time served, you're ordered to pay a $3,000 fine. Your license to drive a vehicle is revoked for 8 years. You must report in person, and this will be concurrent with any other cases that you may have. Thank you.
Thank you, Your Honor.
All right, who do we have next?
Up next, Judge, is Jason Bradford.
Judge, Mr. Bradford intends on entering an agreement. I believe that he is to be arraigned still on the second amended violation, is my understanding. And
Do we have a second amended violation of community corrections? All right, if it was just filed today, we'll need to go ahead and, we need to serve him with it, and then we'll give him a copy at the arraignment. So. To arraign you, this is alleging you were placed on probation on or about July 27th, 2022 for probation violation. You were transferred to community corrections, and that the original charges were child abuse and under 8 years of age and neglect. That's what he needs to be served with. And it's alleged you violated your community corrections probation by violation of Rule 2, which states you would report to your officer on a regular basis, that you have not reported to Dixon since May 18th of 2023. Show that he has been arraigned, the plea of not guilty is entered, and we will set him for the June 29th. Pardon? Oh, you do today? Okay,
yes.
that's fine.
So, Judge, on the violation, amended violation and second amended, Mr. Bradford intends to plead guilty to those. The punishment for that plea will be to serve 6 days or 6 months, day for day, with credit for his time served, and then reinstate community corrections for a period of 10 years, beginning upon his release from the county jail. He's to receive jail credits from February 5th, 2026 to current, and community corrections credits from July 27th, 2022 to May 23rd, 2023.
All right.
Oh, I have you summary.
Judge, just to clarify, although that's correct what she stated, he's going to be reinstated, but he's going to restart his entire 10 years.
So he'll be restarting his entire sentence of 10 years? All right.
After he serves his 6 months.
Mr. Bradford, raise your right hand. Let's place you under oath. State your full name for the record. Mr. Bradford, you're here today on a violation of your community corrections probation. I want to make sure you understand your rights. Do you understand you have a right to plead not guilty and to have a hearing here where the state would be required to prove to the legal standard that you had violated your probation? You speak up because we're recording this. Do you also understand that you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir.
Do you understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by pleading guilty, you're waiving your right to that hearing and to the appeal. All I'm going to do is approve what your lawyers worked out with the state.
Yes, sir.
And do you understand that that's going to require you to serve 6 months day for day with credit for time served and then reinstate you to community corrections to restart your 10-year sentence?
Yes, sir.
All right. Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to that agreement?
Yes, sir.
And upon your plea of guilty, I find you guilty of violating your community corrections probation, order that you be revoked to serve 6 months day for day with credit for time served. Upon your completion of that 6-month sentence, you will then be reinstated to community corrections for a period of 10 years, which is actually restarting your 10-year sentence. That will begin upon your release. All right, thank you.
Thank you, Judge.
Judge, up next is John Wren.
Mr. Talbot, can I see you for a second?
Take the stand.
Never. We're gonna set it up to do him in the morning. So that would be, yes, we'll do it on Zoom. Well, that's fine. If you know, we have the Zoom link already in place for tomorrow. So just give him that Zoom link. All right. Mr. Wren?
This is Mr. Wren, Judge. We have a motion pending before the court. If you recall, I think we were here last week. This was the case where Judge Turnbow, the state had filed a motion to revoke his bail. His original bond was in place. There was, I believe, two sets of charges out of General Sessions Court that triggered a motion by the state to revoke the bail on the first set of charges, which I'm still not sure that Mr. Wren had notice of that hearing. But that being said, he said, well, Judge Turnbow said, well, file a motion if you would like to have a hearing on it. Here we are, Judge. So I'd call
So
Mr.
you want to go in front of Judge Turnbow then?
I'd rather not.
Repeat everything you just said to me about how this has gotten in front of me.
Judge Turnbow, last month, I guess the state had filed a motion to revoke the bail. Mr. Wren, I'm not sure whether he was aware that they got the motion. They filed the motion while he was incarcerated. He made bail on the new charges. I don't think he even received the motion that went to the jail. I come to court because I have Mr. Wren on the initial case, which they were trying to revoke the bail on. And of course, Mr. Wren was not there, obviously. I don't think he had notice. And Judge Turnbow said, well, I'll revoke the bail and issue a capias, and, pick them up, you can file to have a hearing on it. So here we are.
All right.
I'll call Mr. Wren, Judge.
So you're asking me to set aside what Judge Turnbow did?
Well, either set aside or reset the bail commensurate with the situation. Either.
And you're calling Mr. Wren as your witness?
Well, I guess I'm going to have to go back through the 118 factors, but if you would like to hear those.
I'm here to hear whatever that Judge Turnbow has now stuck me with to hear. So.
Okay. I'll call Mr. Wren to the stand.
Mr. Wren, come around here, please.
Mr. Wren, if you would state your name for the record, please.
John Allen Wren,
Mr. Wren, where do you live and how long you live there?
124 Oakwood Circle, Dixon, Tennessee. Lived there 21 years.
All right. Were you born in Dixon County?
Yes.
What other family members you have living in Dixon County?
My mother, my brother, my children, several cousins.
Where's your children live at?
White Bluff.
Are you married right now?
No, of course.
All right. And Mr. Wren, have you ever been diagnosed with any medical or mental conditions that would affect your ability to understand court and come to court and so forth?
No, sir.
Okay. And Mr. Wren, have you ever been charged with failure to appear?
Never, no, sir.
Okay. Have you ever, knowingly failed to appear?
No, sir.
Did you get the notice of the bond revocation motion that was at the jail before you left?
No, what do you mean?
Did you get any mail that said,
No,
hey,
sir.
we're filing a motion to revoke the bail, be here on a certain date?
No, sir. Just when they just brought to me the revoke. They sent me the revocation after I was in jail. After it had done been to court.
Okay, you got it after you've been.
Yeah, they served me a warrant, yeah.
Okay. All right. Now, Mr. Wren, what's your prior criminal record look like now? I'm talking about convictions, not what is pending.
Just what's been in?
Yeah, no.
Oh,
Everything.
prior.
Yeah, what you've been convicted of, not what's pending.
I had a theft charge back in 1995.
Okay. Other than
Something like
that,
that, something like that.
other than that, what else would you have convictions for?
Nothing.
All right, well, that 95 conviction, was that a felony?
Yes,
It was a felony?
I believe so.
All right. Did you go to court on all those?
I did.
Did you complete that sentence?
I did.
No probation left, anything?
Nothing, no.
Okay. And did you post bail on the subsequent charges you got in the city of Dixon?
The charges now?
The charges that were triggered this revocation?
Yes, sir.
motion?
Yes, sir.
All right. Do you recall how much the bail was on those?
It was reduced down to $24,000, the first charge, the one they revoked.
Okay. And then the next one?
47,000.
All right. But you've made those, and then you know how much the original bail was in this case?
Which ones?
The ones
Sorry.
right here that got revoked, this bail.
The 24,000 was original from, that I've been going to court on last year.
All right. So the general sessions cases, how much were they?
They had doubled them. They said they doubled the charges, so there was a 60 and a 35,000.
All right. So they doubled them.
They were doubled, yes. They were doubled from the original.
Judge, I'll pass the witness.
John?
Mr. Wren, are you certain you've only got one felony conviction on your entire history?
To my knowledge, yes, ma'am.
So
I've
if-
only been there, I mean, I was on probation for it, yeah.
So you don't have 13 prior felony convictions for burglaries, thefts, et cetera? Lots and lots of those. You don't have any, you're saying that you don't have those?
Whatever I had was, like I said, 1995. I don't have anything else.
In fact, it looks like you were convicted in,
Is that an objection, Mr. Baker?
No, I didn't understand what you said.
I
Well,
was,
neither did I, but it's not a basis for an objection. Be seated.
so would you be surprised to see that your criminal history shows 13 felony convictions
would you ask, could I ask from when?
from a time period of 1997 to 2002?
I would. I was just convicted at one time.
Okay. And you violated those probations, didn't you?
No, ma'am.
All right. I don't have any questions for Mr. Wren.
You have a redirect? Now you can ask him what he says.
What was that answer?
To which one? I'm sorry.
He may not remember the questions.
I don't even know if I remember it at this
Well,
point.
I think what was said was, she asked if I had other convictions, and to my knowledge, I was only on probation. I went to court one time, it may have been a couple of charges together, I'm not sure, but I was convicted one time, and I served community corrections for it.
Are you talking about one case, but it may have been
It was put
multiple?
together, I guess, but it was not, I don't recall it being to 2000, anything like that. I got on probation in 2002 or something like that.
Okay, but you don't recall, okay.
And I never was violate or anything.
All right, but what I'm getting at is you could have a case that had multiple counts, but you don't recall, you just remember there was
There was a few counts, and there wasn't a lot, though.
okay, fair enough.
All right, at the jail, what is your name, please?
Yes, Green.
Is that your client as well, Mr.
It
Flanagan?
is, Judge, and we are not ready to set it for trial yet. That's General Stovey's case, so we need another status date.
Let's go September 23rd. All right, next status will be September the 23rd. Let your lawyer continue to try to work on your case.
I'll be up to see you, Chad.
All right. Anything about a bond?
Well, that's what I'm gonna come talk to you about.
Okay.
Okay.
Thank you.
And we're waiting on Rebecca Mines.
Judge, I'm gonna have her sign the plea petition,
Okay.
and this will be a no contest plea with a sentencing hearing. So.
All right, Ms. Miles, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Rebecca Ann Miles.
Ms. Miles, you're here on a multi-count indictment in docket number 2025 CR 59, and then you're also here in 2025 CR 294 on a charge of domestic assault. It's been indicated that you want to enter a plea of no contest to 4 of the counts in the first indictment, and that the second one will be dismissed as a part of that along with the other counts. Have you seen or been shown a copy of those charges, talked them over with Mr. Flanagan, you, and he discussed the range of punishments you're facing as well as possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of no, would you mute the jail for me, please? Well, it's indicated you want to enter a plea of no contest or nolo contendere. All that means is you're not going to admit you did anything wrong, but you're not going to contest the state's evidence. And as a result of that, the state will tell me what their evidence would be at trial, and I will use that evidence to find you guilty according to this agreement. You understand that?
Yes, Your Honor.
Understand that you have a right, however, to plead not guilty and to all charges and to have a speedy and public trial by jury.
Yes, Your Honor.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you could not afford your own.
Yes, Your Honor.
Do you understand that trial you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that at trial, you and Mr. Flanagan could confront and cross-examine every witness the state calls to testify against you, and you can bring in your own witnesses by using a subpoena?
Yes, Your Honor.
At trial, you would be presumed to be innocent. You would not have to testify or prove anything. Do you understand that there no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering a plea of no contest to these 4 counts, you're waiving your right to contest your guilt or innocence on those charges?
Yes, Your Honor.
Do you understand that that's going to result in 4 felony convictions, or 4 convictions, and I think it would be all, one's a misdemeanor, and that at that point in time, we will then be setting a sentencing hearing for the court for me to determine what your sentence would be?
Yes,
Do you
Your Honor.
understand that?
Yes.
Do you understand that while you're waiving your right to contest your guilt or innocence to those 4 counts, you're preserving your right to appeal whatever I did in a sentencing hearing?
Yes,
Do you
sir.
understand that? Do you understand everything I've explained to you?
Yes, Your Honor.
Do you wish to plead no contest according to this agreement and waive your right to a hearing?
Yes, sir, I do.
Are you satisfied with your attorney's, well, first of all, let me ask this. Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied that there are facts to support a finding of guilt in your case?
Yes.
And I need you to listen as the state tells me what their evidence would be if this case went to trial. If you'll step aside for just a moment, let the state come up to the podium.
Your Honor, if this were to proceed forward to trial, the state would intend to show that on or around January the 22nd of 2025, Ms. Sanders was operating a school bus for Nashville Christian. On the school bus was a 6-year-old with the initials KO. They were going down Highway 70 and were going to turn left onto Highway 96 in the left turn lane. The state would intend to show a witness coming from Highway 70 going towards Dixon before approaching the intersection, observed a red car being operated in a dangerous manner. Then when going around the curve, this red car ultimately struck the school bus, causing it to ignite and catch fire. The driver, Ms. Sanders, and the 6-year-old had to get off the bus and run up the hill to the nearby church for safety reasons. At that point, whenever officers arrived and on body camera, the bus is fully engulfed in flames. This did place Ms. Sanders and the 6-year-old at risk of serious injury. On scene, Ms. Miles had a gash on her head, but ultimately when Sergeant Deloach went to speak with her, he noticed a strong smell of alcohol from her. A blood vial was ultimately collected, showing her to have a .113 BAC. On top of mixing that with her oxymorphone, 9 nanograms of that as well mixed with it, which TBI would say would have a synergistic effect, ultimately enhancing the effects of each other, not simply 1 + 1. Inside of her purse, Ms. Miles did have a prescription for the oxymorphone, as well as a handgun. Ms. Miles is a convicted felon, and she has ultimately previously been convicted for aggravated assault, which would make this a Class B felony. This is notated on the plea petition. For Your Honor, ultimately, with the sentencing hearing, we'll be looking at 8 to 12 years, which will be the manner of service, and ultimately the length will be decided by Your Honor. As required under TCA 40-35-501, both the child endangerment as well as the felon in possession of the firearm are 100% offenses. That is notated on the plea petition. Those are the facts that the state would intend to show for purposes of the DUI with the .113 and the oxymorphone, the reckless endangerment of the bus driver, the child endangerment of KO, and the possession of a weapon by a convicted felon. Thank you.
All right, Ms. Miles, I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if you went to trial?
Yes, Your Honor.
You still wish to plead no contest?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel that Mr. Flanagan's done a good job of representing you competently?
Yes, Your Honor.
Mr. Flanagan, you know of any reason she should not enter these pleas?
No.
And we need to go ahead then and set a sentencing hearing. I do find that she is guilty in count 2 of driving under the influence of an intoxicant. Count 4, I found her guilty of reckless endangerment with a deadly weapon. Count 6, I found her guilty of child endangerment of a child less than 8 years of age. And count 8, I found her guilty of being a felon in possession of a firearm. We will then set a sentencing hearing. I assume that September would probably be as early as we can get that done.
We could, if you would allow.
July. My criminal docket is on the 14th of July. VOP day would be 28th. We can set it at 1 o'clock on the 28th of July.
Please, because I'll be in trial on homicide.
Is the 28th okay? All right. Mr. Flanagan, is that all right for you?
It is, sir.
We'll set it at let's do it at 1:30 just to be safe, but 1:30. We need a pre-sentence report, yes. July this 28th. Right. All right.
Okay.
All right, at the jail is, are you Ronnie McCoy? You're muted. You'll have to unmute that device.
Yes, Your Honor, I have, Brian McCoy.
All right, Mr. McCoy, your lawyer has asked that you be brought down, so we're going to bring you down so that you can hopefully dispose of this case, all right?
Okay, thank you.
Thank you.
Thank you, Judge.
Next up, I've got Connor Bishop.
All right, you need to talk to Mr. Bishop. All right, we'll put it on the second call. You have another one, Sergeant?
Bring out Jason.
All right, bring him out, please. Good morning.
I represent Mr. Bradford. Judge, on Mr. Bradford's, we're still in discussion about his case, and we're just going to ask to second call it if possible.
All right, we'll put it on the second call. Bring us out another one. Brian Carmona. Mr. Atchison, are you ready on Brian Carmona?
What's up, big guy?
Judge, I'm going to pass forward Mr. Carmona's plea petition as it relates to his VOP. And
Right. Shows that he is going to admit his violation of probation, waive the hearing, and be sentenced to serve his sentence with credit for time served.
That's correct, Judge.
All right. Mr. Carmona, raise your right hand. Let's place you under oath. Thank you. State your full name for the record.
Brian Jesus Carmona.
Mr. Carmona, you're here today on a violation of probation. Do you understand you have a right to plead not guilty and to have a hearing where the state would be required to prove to the legal standard that you had violated your probation?
Yeah.
You understand you'd have the right to have a lawyer and have one appointed if you cannot afford your own?
Yes.
Do you understand that if you went to that hearing and I found you guilty, you could appeal what I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by pleading guilty, you're going to be waiving your right to the hearing and to the appeal. All I'm going to do is revoke you to serve your sentence with credit for all your time.
Yes, sir.
You understand everything I've explained to you?
Yes.
Do you want to plead guilty according to that understanding?
Yes.
Then upon your plea of guilty, I order that you be revoked to serve your sentence with credit for all your time, and your lawyer has set forth all of the days that you're entitled to on this document, okay?
Yes, sir.
All right, thank you, Mr.
Thank you,
Atchison.
Judge. I'll get it to you as soon as they get it hooked up.
We heard from Crystal Wilkerson before we bring out Derek Dillard.
I believe they're back there speaking with him. I've got Kadarius Godwin.
Okay. Darius Godwin, page 6. All right, now I'm ready if you are. Just, if the public defender will cooperate by letting him have that table for us to have this hearing on Mr. Cardarius Godwin.
What?
All right. Yes.
Mr. Bishop is going to get a trial date on that helps the deputies if they can take him back, so.
All right, and we don't need Mr. Tyner Bishop brought out?
No, we don't. I've told him what we're doing. That's General Bryson's.
Right. Well, let's just go ahead, before we start this hearing, let's go ahead and set a trial date. You're wanting a trial date on the sex offender registry violation form, correct?
Yes.
State have a date in mind that you want to try Mr. Tyner Bishop on that charge? Probably looking at January.
Judge, I don't have your trial dates marked, so I think it's a one-day trial.
What about, is it one-day trial?
Yes,
Could be
Judge.
half a day. I think it's going to be non-jury.
January 15th?
That's fine, Judge.
January 15th. The OP will be moved to January 27th.
Thank you, Judge.
All right, we're back on Cordarius Godwin. Defendant's motion to reinstate bond.
I said, we have an order for expungement for the case that was tried in January and February. And I'll call Mr. Godwin briefly, Your Honor, but just to go over some of the things in the motion. Briefly, Your Honor, just to recall the timeline of events as to his bond revocation, the state filed a motion in 2020 CR 192. Court had a hearing on February 21st of 2024, and court granted that motion and sua sponte revoked Mr. Godwin's bonds in the remaining matters, one of which was docket number 2021 CR 256, which we had a jury trial in January and February, and Mr. Godwin was found not guilty. The basis that the state laid out for that bond revocation was a charge in Lawrence County that was dismissed. An officer passed away down there. That was dismissed. And a certified copy of, I believe, the affidavit of complaint in that case was entered over objection. And he's since been found guilty. Would note for the court that docket number 2020 CR 192 and 2020 CR 351 were not.
In this dramatic courtroom hearing, a defendant facing a long list of serious charges reaches a plea agreement after prosecutors reveal he allegedly drove drunk, crashed into a business multiple times, caused more than $60,000 in damage, threatened police officers, and fought with law enforcement during his arrest. The defendant agrees to enter a no-contest plea to multiple charges, including a second offense DUI, felony vandalism, retaliation against officers, and attempted assault on a first responder. Prosecutors tell the court that the defendant's blood alcohol concentration was nearly 3.5 times the legal limit, and that he repeatedly rammed his vehicle into a commercial building, causing extensive destruction. The judge carefully explains every constitutional right being waived before accepting the plea and warning the defendant about the life-changing consequences of the convictions. The most powerful moment comes when the judge delivers a final warning after imposing the sentence. The defendant receives nearly a year in jail, a 2-year license suspension, fines, probation conditions, and the possibility of a restitution order exceeding $60,000. However, the judge makes it clear that this is his last chance. If he fails to report to jail, commits another crime, violates probation, or breaks the law in any way, the suspended sentence could transform into a devastating 9-year prison term. What begins as a routine plea hearing quickly turns into a sobering courtroom lesson about drunk driving, accountability, second chances, and the severe consequences that can follow a single night of reckless decisions. Question: do you think a defendant who causes over $60,000 in damage while driving drunk deserves probation, or should prison time be mandatory in cases like this? Like and subscribe for more real courtroom moments.